Welcome everyone, this is Amr Mushtaq from UCounsel. In today's lecture, we'll talk about Rule 57 of the Rules of Civil Procedure in Ontario. This rule deals with award of costs in a proceeding, and as you know, a proceeding could be a court action or an application in the civil courts in Ontario. We start with our disclaimer that this lecture is not legal advice. If you have any specific questions, you should contact a lawyer or a paralegal, or contact the Law Society of Ontario for a referral. What are costs in a proceeding? There are two components to costs in a proceeding. Number one is lawyer's fee. If you have retained counsel, either for the entire case or partially for the case, you may have incurred legal fees from the lawyer, and you may be entitled to recovering those legal fees from the other side if you're successful. And the second component of costs are disbursements. These could be mediator fees, investigation fees if there was an investigation conducted, copying, binding, faxing charges, court fees for issuing the claim, filing the defense, bringing a motion. There are fees for different steps in a court process, and you may have paid those fees into the court. Attendance money for witnesses. All these kind of out-of-pocket expenses are considered disbursements. There are three types of cost award. First one is called full indemnity, which as I noted here is extremely rare. Full indemnity, what it means is that assuming that, as an example, you have incurred $60,000 in total cost, which includes your lawyer fees, disbursements, and taxes, and you're asking the court that because you're successful in your case, you want the other party or parties to pay you, in addition to the damages, the entire $60,000 of your cost. Now, it is very rare in Ontario, and extremely rare in Ontario, that the court will award full indemnity on a case. In fact, in my 10 or 11 years of practice, I have never seen a case where the court has awarded full indemnity. So whatever you spend, you're not expecting to recover all of it in legal fees and disbursements, even if you're successful. The most common type of cost award is called partial indemnity. And to explain it to you in very simple terms, you are expecting to recover about 35 to 50%, around that percentage of your actual fees that you have incurred. So if you have incurred $100,000, actual legal fees and disbursements, you can potentially recover $35,000 to $35,000 or up to $50,000 generally on a partial indemnity scale. So in other words, you're not recovering the full cost that you have actually incurred on your case. And the third kind of award is called substantial indemnity, which is higher than partial indemnity. And in this case, you are expecting to recover about 75–80% of your actual cost. Based upon the cost award, you can imagine that the cost award is quite important, but let me explain to you this by way of an example. So imagine that you fought a case where you were claiming about $30,000 in damages, but to fight this case and take it all the way to trial, you retain counsel, and your total fees for a 3 to 5 days trial in Ontario or in Toronto would be approximately $60,000. This is a realistic number that if you start a case in Ontario in Superior Court of Justice and you take it all the way to trial and you complete a trial which is 3 days or a little bit longer, it is reasonable to expect that you will incur about $60,000 in legal fees. And let's take this scenario in which the court agrees to award you the entire amount of damages, so you get full $30,000, but for some reason, the court does not agree to award you any cost. So the outcome of this case is that you're literally out of pocket by $30,000, even though you were successful and got full damages. So as you can see, the importance of cost award is very obvious, that you want to fight a case and you want to win a case in a way that you are successful in obtaining a judgment or getting a judgment, not getting a judgment against you if you're a defendant, but at the same time, you're not substantially out of pocket for continuing this fight. And so you have to be very careful about the cost in a proceeding, because we as lawyers know that a lot of times it is the cost that drives the litigation. So for example, if we are involved in a case which is $30,000 or $50,000, we are always worried about what are the costs of that proceeding at a certain point, and how can it play a role in our client or the other side in deciding whether the case is worth continuing or whether a settlement may be a better option. So with that in mind, comes this option of Rule 49, which is in the Ontario Rules of Civil Procedure, and it talks about how to strategically make offers to settle so that you can benefit better even if you continue a court fight for an amount that is not substantially very high. And because the topic is important, I will provide details of Rule 49 in a separate lecture. Now, coming to Rule 57, which is the one in Rules of Civil Procedure of Ontario, which deals with costs. The first thing you want to remember about cost award is that it is usually awarded after each step in a proceeding or after trial. So if you have brought a motion or you are dealing with a motion, defending a motion within your action, at the end of that motion, the court will generally award costs to the successful parties. It also happens sometimes that the court may reserve the cost award to the trial judge, but usually the motion judge or the motions master will award costs to the successful party after each step. And obviously at the end of trial, the successful party usually gets cost award in addition to the judgment. The key principle that you want to remember about cost award is that it's at the discretion of the court. That's one thing that you want to carry from this lecture, that it is the discretion of the court to award cost, and whatever the court finds that this should be an appropriate cost, that is what the court is going to award. And what you want to remember is that because it's the discretion of the court, it is very rare that if you appeal a cost award, it may be changed or overturned by an appellate court. So because of the discretion of the court, whatever the judge or the master has decided, that will usually remain the cost award in your proceeding. Now, usually, cost is awarded to a successful party, and I say usually, but it is possible for the court to award cost against a successful party. Rule 57.01 sub 2 specifically allows the court to award cost against the successful party. And so you want to keep this in mind, because I have seen cases where a party was successful, they won the case, they got the judgment in their favor, and yet because of their conduct during the action or because of the factors that the court considers in awarding cost, the court actually awarded cost against the successful party. It doesn't happen that often, but it is possible. So even if you're successful, you want to be careful about how the cost award is going to play out in your specific proceeding. Now, what are some of the factors that court considers in awarding cost? It's under Rule 57.01 sub 1. One factor is lawyer's experience. The lawyer that you have retained, how experienced that lawyer is, what are the rates that the lawyer charges, and how many hours the lawyer has spent on your case. Another factor is ability of a party, unsuccessful party, to pay. So it is a factor. Just because you cannot pay the cost does not mean that the cost will not be awarded against you, but it is one factor that the court will take into account, whether you have the ability to pay costs and what is your ability to pay costs. Amount claimed and recovered. This is an important factor, and this was at issue in one of the recent cases in cost award. If you have claimed $20 million in a case and you recovered $20,000, do not expect that the court is going to award you significant costs, because you have claimed a hugely exaggerated amount, whereas the actual recovery was a small fraction of that. So this is something to consider when you're making those claims. You want your claim amounts or monies to be somewhat realistic of what you can potentially recover. Complexity of the case, complexity of the issues is also a factor in when the court is considering the award of costs. Importance of issues. If you brought a court action, which not only is helping you in succeeding in whatever you're claiming, but it is also beneficial to the larger public, it could be a public issue, then the court will consider that when awarding costs. So in circumstances where you commenced a court action which was in public interest, and even if you were not successful, the court may take that into account in deciding that you may not have to pay significant costs because you raised an issue that was helpful to the public at large. Conduct of parties. This is a very important factor, and the courts do consider this very seriously in deciding what are the appropriate costs. So to understand this better, if a party acts inappropriately or unreasonably in the conduct of an action, so not just at trial, but from the time the action was commenced to the time it goes to trial, if one party, for example, takes steps that unduly delay the proceeding to move forward, brings motions that are unwarranted just to cause trouble to the other side, just to make it financially difficult for the other side to continue the litigation, then all of those factors are considered at trial, and the court may, because of the conduct of a specific party, award cost a bit heavily against that party. So conduct of parties is important. Refusal to admit. If one party has asked the other party, submitted a request to admit and asked for certain facts that are not controversial, or even if they're controversial, but they believe, one party believes that those facts were true, the other party can submit or serve a request to admit. And if the second party refuses to admit those requests, then there could be consequences to that. This is also an important topic strategically in a court action, and I'll have a separate lecture on refusal or request to admit. And then there could be any other matters that the court believes that should play a role in deciding what are appropriate costs, and the court will take that into account in awarding costs. So in conclusion, the main thing you want to keep in mind is that you always want to carefully consider cost consequences, because costs play a significant role in how the overall outcome of your case is going to take place. And so you have to take steps and implement strategies so that even if you're successful, there are no negative cost consequences to you, or even if you're unsuccessful, you are managing the cost consequences to the minimum. And similarly, you want to implement strategies so that not only that you get highest damages or get the case thrown out against you if you're defending it, but you're able to get highest cost award so you're not financially disadvantaged at the end of trial. Hopefully this gives you some understanding of a cost award, and I will, as the next lecture, talk about Rule 49 offers so that you can get an overall perspective on cost and how to play with cost strategies in your proceeding. Thank you for watching.